Thank you all, so many people, for coming back a second time. To the disappointment of my late wife, I preserved an interest in the writings of Henry James, the great American novelist. And Henry James would often have these long, winding sentences where you couldn't tell what was being said until the last word falls into place. I want to recall one of those sentences for you now. And I'll repeat the last word because you will not hear it even if you were next to me because it's not the word you were expecting. It's from a story called The Abasement of the Northmores. And the narrator, speaking of Lord Northmore, says this: he made a great manner and a great many mistakes. He made politics, he made land. He made a bad manner and a great many mistakes. He made a gaunt, foolish wife, 2 extravagant sons, and 4 awkward daughters. He made everything, as he could make almost everything, thoroughly pay. Thoroughly pay. Now, what I'm going to offer you today is not going to be that curly. But I'm taking a lot of turns here. Nothing too complicated, but I'm taking turns. I'd ask you, stay with me until the last piece falls into place, okay? Aristotle, with his gift of teaching, put the question about the political order in another way. He remarked in the Politics that the end or purpose of political life was to enrich people through commerce. Who would have the better claim to rule in the political arena than the successful businessman who's already made his success in making money and preserving it? And if the end of the state were the safety and the securing of the residents, who would have a higher claim to rule than the military man who's already shown his proficiency in the skill of using arms and the conduct of warfare? The safety and the material well-being of the populace were indeed part of the legitimate concerns of the political order, but they didn't exhaust or quite touch the highest concerns of political life. As Aristotle said, the dominant concern of the polis was not confined to the protection of life, but in shaping the character of a good life, a life of good character, directed to the rightful ends of a decent people. But if it wasn't the art of the businessman or the art of the soldier that was needed, who would lead or rule in a political order? What was the art that we're looking for? I used to say to my own students that you're old enough, even between the ages of 18 and 21, to answer this question: was a rich father a better father than a poor father? They knew enough to know that wealth is not the measure or the predictor of things here. What is wanted is the deft hand of fairness or justice. Socrates was not being a bit too heady when he said that he was the only true legislator in Athens, for he alone possessed the political art, the art of reflecting about the grounds of judgment, about the things that were right or wrong, just or unjust. But he was quickly and rightly twitted by Callicles in Plato's Gorgias. He said that Socrates does not know how to speak to the multitude of people in the city who are not philosophers. He will not lower himself to meet them at their own level. And so, as Callicles said, with historical accuracy, Socrates will be hauled before a jury and he will not deign to speak the words needed to defend himself. Yes, one needed the capacity to reflect on the things that were just and unjust, but one needed also the skill to speak to the public, to give reasons that ordinary people can understand. Aristotle touched the core of the matter in the Ethics when he said that the study of politics may not hold much interest for those people, young or old, for whom life consists of a series of disconnected emotional episodes. But for those people who are generally concerned, there may be some connection in principle between the judgments they made last week and the judgments they make today. And for those kinds of people, the study of politics could be quite instructive. In other words, the test of legal, political, moral judgment is whether a man can give reasons for his actions and whether he can show a principled ground for his motivations. Can he explain the principles that connect what he does this week to what he did last week and what he may do in the weeks and years to come? As Thomas Aquinas taught us, the first principle of practical judgment is that the good or the right is that which everyone ought to do. The wrong is that which everyone is obliged to refrain from doing. The good is higher than the bad, more desirable than the bad. And so the knowledge of the good, the knowledge of right and wrong, is the higher than the knowledge of merely technical means, because the knowledge of right and wrong is better than an ignorance of right and wrong, or life lived with indifference to right and wrong. Higher than the knowledge of driving the car, for example, is a knowledge of the ends for which the driving of the car is rightful or good. Is it better to drive an ambulance or drive a getaway car for the mafia? This leaves us with the uncomfortable question, well, who does the highest work in this society? Who has the highest art or science? The science that directs everything else. Aristotle remarked that anyone who would become a father must acquire the arts or the science of a legislator. He knows what is good or fitting for himself, but in governing others, he'll need to know something about those principles that tell him what is more universally good and rightful for others apart from himself. The doctor treats patients in the light of the universal knowledge that makes up the science of medicine. So what is the science that one needs to know if one has responsibility for the care and the condition of a community? How to preserve its moral character, the terms of principle that are rightful in our lives together, and the character of the people we're trying to cultivate in this community. It's far from easy, Aristotle said, to obtain right training in goodness from youth upwards unless one has been brought up under the right laws. So what is the science we need in forming the laws that will guide the character of the people? The science that treats particular cases with practical wisdom, drawing upon universal principles. It must be a faculty, he says, in which ultimate authority is rested, and he calls that faculty finally political science. Political science. If we ask Aristotle, what is the highest art? His answer is one that predictably jars people or leaves them scratching their heads now. He backs us into the notion that the highest science is political science. Now, I have seen political scientists gathered in large numbers, let me tell you. And when they're assembled in mass, they don't exactly strike you as the kind of people you would trust to rule the world or even get to dinner made on time. But political science at its best is the science of reflecting on the principles of justice, the nature of the just political order, and the things we are justified in imposing on people with the force of law. Aristotle backed us into the recognition that of political science as the architectonic science, the science that knows the first order principles that give proportion and scale to everything else. Or what about people working on new drugs that deliver us from high blood pressure and prostate cancer, diabetes, and other ills? Wouldn't that be more important than something like political science? Well, as important as such life-saving research is, science itself still works under the governance of moral principles that are even higher. For there are moral limits on the way that science acquired what it wanted to know. Some of the research carried out by the Germans during the Second World War had considerable utility for people in other countries. We want to know just how icy were the temperatures that pilots could bear if they were downed in the Atlantic. What better way to define it than by dunking a few prisoners we had in concentration camps, because as the line goes, they were going to die anyway. And yet we seem to have been clear in this country, at least clear until recently, that we should not do lethal experiments when there were alternatives that were non-lethal. And we shouldn't do experiments with lethal risks on patients without their consent. These moral inhibitions could indeed slow the pace and limit the reach of research. But we seem to understand that there were, as I say, serious moral limits even on what scientists deeply crave to know. And now in our own day, we're faced with the choice of whether we're going to do research on stem cells extracted from embryos, killing these nascent lives, or whether we'll use adult stem cells or newly contrived induced pluripotent stem cells. They can be contrived without killing live human beings. The new methods involved here would allow us to produce the equivalent of embryonic stem cells without creating and destroying embryos. And this is exactly the problem we're having now in intravitreal fertilization, creating extra embryos and destroying them. And here, my friend Ted Cruz and Republicans have tried to sort of sweep by those things on the way to try to assure people that, no, we are very much in favor of in vitro fertilization. The distinction is critical because each one of us began as an embryo, and it was all there in our genetic makeup. I remember Paul Ramsey, the one line that got to me, that everything we have genetically, he said, we had when we were that zygote, no larger than the period at the end of this sentence. It was all there, our allergies, our height, perhaps our SAT scores. When we make a decision to allow the destruction of embryos in research, we make a decision at the top of the state about the kind of work we think legitimate and salutary, the kind of work we're willing to encourage by removing the moral and legal inhibitions and licensing, encouraging, and promoting the work. And so a whole new industry arises with many people working in labs. My point, though, is this. A decision is made by legislators, by people making laws. They're engaged in the highest practice of political science, and the decision they make will either foreclose many people from making their livings in a branch of research involving the use of embryonic stem cells, or they will remove the inhibitions and cause that kind of work to burgeon. In the past, when we see prostitution restrained, abortion barred, when we bar men and women from producing pornographic videos, the law and the community are conveying the point that this is not the way that a decent people, a decent community should be making their livings. Aristotle curiously had it right. Political science, or maybe more accurately say, the moral sciences, would be the architectonic science. They give proportion and scale to everything else. It even decides what kinds of occupations are fit for a decent people. And of course, it must affect what people are taught in schools about the ways of making a living, the principles that may rightly frame and shape their lives. Now, this is the age of diversity enrollments. Colleges have been recruiting students from more and more exotic places. But do we care about the kind of commitments they bring to college if they've absorbed the principles of those regimes from which they come? Or are they going to bring back to their regimes, as our friends from China here are, something that will bring something better back to those regimes? As Aristotle taught us, the good man and the good citizen are the same only in a good regime. If we brought to the campuses in the 1930s a German student who was deeply loyal to the Nazi regime, a student who had absorbed within his character the principles of that regime, how might it have mattered? We can hardly do better here than to recall the case, a notable example, of that famous member of the Harvard class of 1921, Isoroku Yamamoto, later Admiral Yamamoto, the early advocate of naval aviation, who commanded the Japanese fleet of ships and planes for the attack on Pearl Harbor. People may not recall that Yamamoto had a real affection for the United States. He went to school here. He was opposed to the war with the United States. He was opposed to the invasion of Manchuria. He was opposed to the pact with Hitler and Mussolini. but he thought that the highest honor was to die in the service of the empire and the emperor. He liked America, but he loved even more the Japanese regime. It was found years ago in a survey that non-U.S. citizens were enrolled in American graduate programs. About 245,000, about 55% were in engineering and the physical sciences. Many of them were in public universities, supported by public funds. Years ago, New York State tried to limit public education to citizens or to resident aliens who wished to become citizens. But the Supreme Court struck down that move. But the court missed the importance of a critical moral question. By the time a person has reached college age, why would it not be apt to ask, are you clear on your own moral commitments? Are you clear on the character of that political regime that commands your allegiance in principle? For if you're committed, say, to using your skills as an architect, an engineer, to go back to Germany to help Albert Speer find ways even more efficient for conveying people to the killing centers, or to become an engineer for Saddam Hussein or the current regime in Iran, what moral principle would oblige us to tax the American people for the sake of perfecting the skills for the service of an evil regime? And would it be gross or reflective of a narrow parochialism even to raise that kind of question? Or would we rather be showing a respect for the student himself as a moral being with serious commitments standing before him? Or show that we as a country do take as profoundly serious those moral terms in which we do live together here? But of course, in that respect, by the way, in this respect also, I met a student last night from China. We have some people here who are going back to China to take up a ministry, to plant the word of the Lord there. These are people who are going back to do the kinds of things that will, the only kinds of things that will change that regime for the better. But of course, as we raise these kinds of questions for resident aliens, we'd be asking more of the resident alien that we ask of people who are born in this country. When aliens seek citizenship, they're required to take a simple course in civic instruction to learn more about the history and institutions of this country. And they're asked to take an oath of allegiance to the preservation of this Constitution or this Republican government. It surely must be a question ever plausible and lingering as to why we don't ask the same of people who are born here. Ask them, say, to take a comparable exam on American institutions, the Constitution. Ask them to consider whether they really wish to affirm their allegiance to those principles on which we have founded our civic life together. If they're reluctant to affirm that commitment, look, they could continue to live here under the protection of the laws, the way resident aliens and their children live here, and they do not vote. To admit someone to the office of a voter is to share with him political power in choosing the people who make our laws and govern us. And why would we do that incautiously with people who do not really share our understanding of the terms of principle on which we want to live here as a community? That matter was revealed to us in a dramatic way in the elections in Germany in 1932 that brought Hitler to power. The voters had before them a wide range of choices in political parties, the parties that filled out the political landscape. But the question always lurking and curiously unrecognized, even now, and even by Americans, the question lurking and unrecognized was that the choice of a candidate is just one part of this process. The point running ever deeper is whether the voters are aware that in voting, they're doing more than choosing a candidate and a new administration. The question is whether in voting, they're also affirming the rightness of a government by consent and free elections, and affirming the rightness of that government for people in all the adjoining voting booths. For obviously, there are people voting in Germany who are not registering their commitment to preserve that form of government for everyone around them, for they're willing to vote for a political party that was threatening to strip civil and natural rights from people in the adjacent voting booths. As Lincoln and Thomas Aquinas alert us, we cannot coherently claim a right to do wrong. That person we recognize as a moral agent, the one who can reason about his own well-being and the well-being of others, that person may come to understand, as Lincoln and Aquinas said, that we cannot coherently claim a right to do a wrong, even in the name of our freedom. And his office as a voter should alert the voter to the point that if he respects the ground of his own equal rights and a government by the consent of the governed, he has a duty as a voter not to permit himself to vote for a political party, whether a Nazi party, a communist party, a Castroid party, that would end the regime of free elections for himself and everyone around him. We had a word to refer to some of these rights. Those rights we are not free to waive or alienate for ourselves. We used to call them unalienable rights. Here in America in the late 70s, we had the scandal of a bunch of self-styled American Nazis threatening to march through a Jewish neighborhood in Skokie, Illinois, with brown shirts and swastikas. And as public outrage grew, the American Civil Liberties Union ran to defend the Nazis, their freedom to march and express themselves under the First Amendment. And Dave Hamlin, I was involved in the arguments then. Dave Hamlin of the ACU instructed us that we have a right to hear the Nazis because we have a right to choose the Nazis. Really? A right to choose the party that removed the regime of free elections and the rule of law, the independent courts? Our supposed right to choose the Nazis would emerge from that proposition, as Lincoln called in the Declaration of Independence, that the only rightful government over human beings depended on the consent of the governed, manifested in free elections. But the Nazis were a party that rejected at the root the premise of all men are created equal. As they rejected that, they rejected the free elections that flow from that premise. We can affirm then the right of to choose the Nazis only by rejecting the moral premises of the American regime. All men are created equal would not then be, as Lincoln and the founders thought, a self-evident and necessary truth. It would be merely just one opinion, no more or less true than any other opinion on offer in our politics. And so, as I said at the time, when I was invited by the ACLU years ago to make the other side, I said, the real crisis here did not involve a bunch of ragtag characters calling themselves the American Nazis. The deeper crisis involved the fact that lawyers, drawn from the most prestigious colleges and law schools, no longer understood the premises that defined their own regime. They, to use an old phrase, they no longer respected the very premises on which their own freedom was grounded. To move to protect the Nazis and the exponents of genocide, to protect them under the First Amendment, marks a slide into moral relativism on the part now of conservative justices as well as liberal justices when it comes to the regulation of the speech. As even my dear friend Samuel Alito has said with Neil Gorsuch, there is no idea now so offensive that it cannot be legitimate, no idea so offensive that it cannot be protected by the First Amendment. The conservatives have been moved to this position out of a desperate concern that conservative voices were being canceled and blocked out of the academy and other parts of our public square. As I've argued, that move has not worked actually to protect conservatives, but rather it's worked to remove the moral ground on which we can continue to protect innocent speech for anyone. All this has been quite far from the understanding of the American founders. John Marshall had famously said that anyone who publishes a libel in this country could be sued or indicted. He could be sued for personal damages, for destroying a reputation, or he could be prosecuted for stirring up hostility to a racial and a religious minority. What Marshall and other founders grasped was that there was nothing categorically innocent about speech. Speech could be used as any other part of our freedom as a vehicle for inflicting unjustified hurts, as in threatening phone calls or letters, the speech that destroys reputations and businesses, or the burning of crosses outside the home of a black family. The ACLU and many people tutored on the Bill of Rights persistently make the mistake of reading the text of the Constitution in a one-dimensional way. They light upon words such as speech and assembly and property, and they remove those words from the moral framework that must always encompass them. It's an insight I attribute to Immanuel Kant when he said, for any class of acts we can name, there will be a set of them that we should not be free to choose. The insight, I think, here is there's nothing we can name, no thing, no activity that could not be part of a means-ends chain leading in a wrongful direction. Again, I could use my skill of driving to drive an ambulance or a getaway car. I could use a pen to make a donation to charity or to commit fraud. That the founders grasped these things from the beginning can be seen from the fact that they were constantly aware of the difference between liberty and license. They recognized that every practical act, every exertion of our freedom could be used for a rightful or wrongful end. Justice Robert Jackson caught the matter here when he remarked that no liberty was ever rendered more secure by teaching that its exercise is inseparable from its abuse. The core mistake, again, is to fail to see that nothing we can name can escape its emplacement in a moral framework. One of the most notable places in which commentators fall into confusions over this matter come with arguments over the rights now of parents and the family. One could actually begin here with the Ten Commandments. Commandment 5, honor thy father and thy mother. Now, if we step back for a moment, God could not be enjoining us simply to honor our biological father or mother. For in that case, we'd be obliged to honor the man who sired me in the course of a rape, or the mother who abandoned me. The commandment must take on its deeper meaning with the moral premise that it was assuming and folding in, that we honor the parents who fulfilled the moral definition of parenting, the parents who were there to nourish and protect. But this matter comes into play strikingly in our law right now. I never thought I would live to see the day in this regime in which parents could be threatened with legal penalties or with the loss of custody over their children if they sought counsel for a child who's undergoing confusion about her sexuality. Or even worse, a child being guided by counselors on a path to hormonic treatments, leading in most cases to surgeries on transgenderism. What we'd be invoking here in defense of parents are the claims of those who bear those natural affections to the children they have born and nourished, the children they wish to bring to maturity with their character rightly formed. This says nothing about the parents who feel little natural attachment or attendant calling to moral guardianship. They're parents who have a mercenary interest in their offspring, quite willing to use them for their own interest, perhaps rent them out for pornography, or neglecting their needs, medical and moral. There's that old Woody Allen line, that this is a watch that my father, on his deathbed, sold me. Okay. I get one laugh out of that? Whoa. I'm in a different place. Well, then there are also those well-meaning parents who may be led or misdirected or even with a manipulated sympathy to let their kindness or their penchant for being nice lead them to gratify the heartfelt wishes of their children while betraying their sober judgment. And so we find parents invoking their claim to parental authority. When the state of Tennessee, in March 2023, acted to bar providers of health care from performing, quote, gender-affirming surgeries and administering hormones or puberty blockers to transgendered minors. The suit was brought by parents of children who are experiencing gender dysphoria. Their concern for their children made them susceptible to the so-called counsel of teachers and consultants that their children were in danger of committing suicide if they were not treated immediately. The claim is spurious on several grounds. If the children are left alone, most of them will simply grow out of their delusions that are fed now by a fad fueled by social media. The children will come to see, even without expensive therapy, that they were not born into the wrong bodies, but the bodies that were none other than their own. But at the same time, there's been a grave danger of suicide on the part of young people, awakening to the disfiguring of their own bodies with mastectomies and penile implants, and facing a life of infertility. The legislature in Tennessee had in hand a sufficient record of experience, and so it registered its concern to protect minors from physical and emotional harm. Certain treatments for gender dysphoria, the legislator said, can lead to minors becoming irreversibly sterile, having increased risk of disease and illness, or suffering adverse and sometimes fatal psychological consequences. The parents were invoking medical authority, and the tricky problem for the legislators and judges was to counter the false claims to medical authority on the part of people adorned at times with medical degrees, but aligning themselves with a new ideological perspective on medicine, putting themselves at odds with the most objective truths that science can indeed confirm to us about the way we are constituted by nature in our sexual identities. Those hard truths of who we are may work to alert us again that the notion of parental authority is not a source of a categorical claim to authority. Parental authority has a moral ground for the rights of parents to seek the protection of children who are theirs, sprung from their loins. But that authority cannot possibly entail a license to guide children, even with the best intentions, to forego the medical treatment necessary for the protection of their lives, or the kinds of treatments flying under false medical colors that may maim and disfigure them and blight the rest of their lives. Now, that's not to say that the government has a warrant to step in to counter any parental advice that may lead children to the choice of a career that they may not find enriching. But at a certain level of hazard and serious harms, we're reminded that children are not simply the property of their parents to act upon with no moral restraint. With that understanding, we've long recognized a moral standing for the community to act through the laws in casting protections over children. That stand found its deeper, definitive ground in this case from Tennessee. And in all the cases now for transgenderism, that recognition confirms to us that this passion, this unrelenting campaign for transgenderism, rests on a predicate that is objectively and just irremediably false, for no one has been born into the wrong body. The Congregation for the Doctrine of Faith, years ago under then Cardinal Ratzinger, noted that there's not always been an Italy or a Hungary, but as long as there are human beings, there must be males and females. That difference in the way we are constituted as human beings marks the very purpose or telos of, and meaning of sexuality. We are built this way for the very purpose of begetting, for bringing forth new life. Those fervently sought and highly touted surgery for sex change produce dramatic cosmetic changes, to say nothing of striking ventures in dramaturgy, but what they do not produce is a change in sex. As Professor Gerard Bradley noted in a recent brief, the transgendered surgeries have never succeeded in providing any patient with the sex organs or reproductive capacity of a member of the opposite sex. But these operations nevertheless succeed in making anyone who undergoes them permanently sterile. Professor Bradley drew out some of the telling points here. The inedible biological differences between male and female inhabit every one of the bodies, trillions of nucleated cells. Sex is in the most profound way, indelibly imprinted upon every part of our bodies. Sex is therefore immutable. But to take this straightforward account of what is immutable and inescapable suddenly draws us into the strange reticence that attaches even to conservative judges and conservative jurisprudence. These judges are so cautious and so conventionally averse now to moving outside of the text of the Constitution that they become shy in appealing to the most objective truths grounded in nature that could provide the most invincible ground for their judgments. Chief Justice Jeff Sutton in the Sixth Circuit is one of the most brilliant and fastidious judges I know, and I must confess, a very dear friend. And when he wrote for the court in the case from Tennessee on transgender surgeries, he was constrained by framing the judgment as a judgment that was needed to dissolve a preliminary injunction. That injunction issued by the district court judge sought to bar the law from blocking the judgments of parents on the medical treatments they thought they wanted to order for their own children during their affirming care. Judge Sutton might have conjectured that his own position would bear up in the end. But in the meantime, Sutton retreated to a ground of judgment far more tentative and less decisive. He acknowledged the growing recognition of the courts of that claim to parents to the governance of their children. And yet becoming a parent, he says, does not create a right to reject democratically enacted laws. But then what can be said in justifying the intervention of the law in this case, wresting the decisions on transgender surgeries from the hands of parents, instead of appealing to the deep objective truths that underlie the legislation in Tennessee? Judge Sutton, in an echo of Justice Scalia, converts the question into one of a democratic process. The question is whether the people of this country ever agreed to remove debates of this sort about new drug treatments from the conventional place for dealing with new norms, new drugs, new technology. The democratic process, the votes of legislators. But what is that medical debate about? Surely not the question of whether males can be turned into females or females into males by artful surgery. Why the need then to shy away from the compelling account of why that law in Tennessee was justified? Why the need to preserve this is a question of the legislature pronouncing on a medical procedure that has been rendered controversial only because of the ideological drive of people swollen with high theory to seek a life of sexuality liberated from the restraints of nature. Judge Sutton might have been inclined to be more cautious because he had come to regard these parental claims of rights as his mentor Justice Scalia had seen them, as having a touch of the constitutionally dubious, as a species of substantive due process. These assertions of parental rights had their sharpest statements in cases in the early 20s, Meyer versus Nebraska, Pierce versus Society of Sisters. The Myers case sustained the right of parents to have their children instructed in German. The Pierce case involved the liberty to direct the education of one's children by putting them in a private Catholic school. But what drew the debate of Justice Scalia was that these primary rights of parents were mentioned nowhere in the text of the Constitution. They're not recognized as something of constitutional standing that had a claim to be protected by federal judges. What we had here even now is that tendency to insist that the due process clause can deal only with questions about the regularity or fairness of procedures, but not about the substance of the legislation. Here, the complaint about substantive process is that it's an oxymoron. If we're challenging the substance of the legislation, it cannot be a matter merely of due process. And yet that slogan has run against the grain of jurisprudence running back to Daniel Webster, insisting in the old Dartmouth College case that it cannot be enough to say for any act of legislation that it was passed with all the trappings of legality and the vote of a majority. There's still the question of whether the enacted law was consistent with a substantive justice. When we say that any act should be weighed against the law of the land, the test is not satisfied by asserting that any newly passed enactment is indeed the law of the land. But the most embarrassing test case here for the opponents of substantive due process has been that dreadful case of Buck versus Bell, the case involving the compulsory sterilization of Carrie Buck, a woman judged to be retarded. She was expected by the so-called experts on genetics to keep reproducing her kind, and her kind was thought to be quite expendable. This was the case in which Justice Holmes notoriously said that 3 generations of imbeciles were enough. It's rather jolting to realize that his decision was hailed at the time by some of our preeminent scholars as the gold standard in jurisprudence. Yet it's hard to find a case more universally reviled by scholars and judges today. But then the surprise comes when we ask our colleagues, well, what standard of judgment use? What clause in the Constitution would you use in striking down the laws of a state that prescribed this compulsory sterilization? It can't be found in the text of the Constitution, the right of parents to educate their own children. If we can't find that, we could surely not find any right not to be subjected to compulsory sterilization. One way or another, the judgment would have to depend, in part, on the argument that the legislature did not know enough about genetics to pronounce a judgment on the characteristics that were genetically transmissible. The late Walter Burns was a scholar of high standing among conservatives. In one of his earliest journal articles, he made the case there was nothing other than the Due Process Clause to protect people like Carrie Buck. Even Justice Holmes said he recognized that the correct procedure may be nothing more than an empty shell on which injustice is done. In the end, procedural due process is, he said, a substantive right. It seems reasonable to conclude that the extent to which the court probes the record of a case would depend on the need to probe the substance of the law involved. And that brings me back to Judge Sutton and the question of transgenderism. Apparently, he did not think he could appeal to the inescapable truth that make transgendered surgery a mad and deeply wrongful project. He would simply say for the moment with sobriety that judges should be wary of removing as vexing a novel topic of medical debate from the ebbs and flow of democracy by construing a new the unamendable federal constitution to occupy this field. I can understand the reasons that moved Judge Sutton to be cautious, but that line could have served just as well as a concurring opinion in Buck versus Bell. Well, this is a matter of genetics and retardation as a field yet to be explored more fully, and let us not be so quick to reject these findings of the legislature in Virginia as it deals with a grave question freighted with controversy. But with a decent respect for judicial restraint, could we not have done better than settling, even for a moment, with an opinion that could fit quite as comfortably as a concurring opinion in Buck versus Bell? And even though we're dealing with an opinion to dissolve a preliminary injunction, might we not raise the question of why we should be constrained at this moment, or any other moment, from recognizing the evidence and reasoning behind the objective truth that finally underlies the judgment of the legislature in Tennessee? But of course, what can be said here about this case can be said with even more force about the holding of the court in the now famous Bostock case on transgenderism. In that case, Justice Gorsuch unloosed a ruling that will disfigure this culture on a scale even worse than Roe versus Wade. He found that it was a violation of the Civil Rights Act, a discrimination based on sex, that Anthony Stevens should be turned away from his job, not because he presents as a female, but because he earnestly believes he's become a female. And if the people around him, his employers, refuse to respect that judgment, they could put themselves in and at risk for establishing a hostile work environment. Justice Gorsuch came to this novel reading of the statute through his tenacious insisting on the meaning of the text in the statute. But of course, it was hard to imagine that any of the congressmen or senators passing that act in 1964 ever thought that discrimination on the basis of sex ran quite beyond differences between males and females and entered the terrain of judging gender identity. But regardless of what the dictionary said, in 1964, the meaning of sex is anchored in an objective truth about the way we are constituted in nature as human beings, quite apart from anything said in the dictionaries of the time. But I fasten on this point because it reveals, again, in a telling and sobering way, the lingering fearfulness of conservative judges to move beyond the text of the Constitution to those anchoring moral truths that the founders had drawn upon, or those objective truths on the way we are constituted as males and females, truths that would never depend for their truth on whether they happen to be mentioned in the text of the Constitution. The appeal to those anchoring truths, I go to my conclusion, the appeal to those anchoring truths, they were there before the Constitution. As I've been suggesting, that is the key. It remains the key that opens us onto the ground of a more morally coherent jurisprudence with a more compelling account of the ground or the source of our rights. Judge Parker in Alabama, in the recent case on in vitro fertilization, opened himself to ribbing and ridicule when he put the accents on rights that flow to us by nature, from the author of the laws of nature, and that creator who endowed us with rights. But Parker was saying nothing more than was said in the Declaration of Independence, in that proposition, as Lincoln called it, establishing that no man has by nature the rightful rule of other men, the way God is the ruler of men, men the ruler of dogs and horses. Without a trace of apology, founders such as James Wilson would expound that understanding with an erudition aptly measured to the state of mind of the most urbane circles in his time and ours. And once we are there, once we're brought back there, to the moral ground of this regime, we're not only brought back to the moral ground, but we're brought back also to the solution that may ease the mind of judges who may be earnestly worrying now over whether they can be accused of having their convictions as Christians or Jews flow over into their work as judges. They may seek a guide for the perplexed as they cope with the fears that something in our religious tradition would create a flaw or disturbance in our jurisprudence. But once again, my pitch is that the natural law, detached from revelation and from all things sectarian, the natural law may deliver the religious from their anxiety and restore to ordinary folk the law they can once again understand. Okay.